for the audience of this conference and the legal practitioners that are really, dealing with data protection firsthand, with a subject access request, with the complaints, this framework that I will now present may seem much more general, but you will see the full relevance and topicality of this framework. So basically around the same time as the OECD decided to revise the guidelines and the European Commission came forward for a proposal of a new framework, the Council of Europe also decided that the convention should be updated. There were two reasons for that. The first one was, although the text at the time was drafted in a very general way and with zero reference to any technology, which means that the text is still fully relevant, there was a feeling that data protection as a right had evolved and that complementary principles could be brought in the convention. That was the first point. So it was the idea to reinforce the protection of the individuals. The second objective of the modernization is to strengthen the control of the implementation of the convention. That is really to give teeth to the convention. I have to admit that at the moment, it's one of the lacunas of the convention. The convention is open to ratification by all Council of Europe member states without any prior screening of their internal system. This will change with the new proposal. There will be a prior check of newcomers, and there will be regular controls of the implementation by the parties. This is really key for the credibility of the convention in the future. The role and the potential of the convention is huge, but we need this, in particular in light of the question of transborder data flows. So this has been really an item of focus in the modernization work. So while modernizing the convention, clearly the idea is to continue to promote it as a universal standard. As I said, since the beginning it was drafted this way. And this is why this convention, unlike all other conventions of the Council of Europe, is open for signature to non-member states of the Council of Europe. So already 32 years ago it was clear that the intention was to have a treaty that would be open to any country in the world. While over the past decades, clearly the focus has been on our member states, now we see that we are nearly at the limit because out of our 47 member states that I mentioned, we now have 45 of them that have ratified. The latest one being the Federation of Russia that recently ratified and will become a party effectively on the 1st of September. So we only have 2 countries missing actually to our 47 list. That is San Marino and Turkey. And Turkey, for a very simple reason, they do not even have a data protection law at the moment. They're working on it. So that would be the first step. Once they have this law, once they have also enforcement capacities and supervision of the implementation of the law, then they would come to us. And they are actually very closely following the work. They have been as observer in our committee. So we want to preserve the general, simple, flexible, and pragmatic character of the convention, which basically makes its success. You will see we've been speaking about simplicity, complexity. It's a complex field, but here the convention is safeguarding general principles that can pretty be accepted by many countries around the world.